Yes, sir.
All right, what is your name, ma'am?
Scarlett Lick.
Thank you. Mr. Barber, it looks like he's present, but sir, you got to unmute.
Hello?
All right, thank you, sir. All right, so we have, looks like two matters on the docket today. We have a petition from the front of the court as well as then a show cause against Ms. Lick. First, I'll start with the front of the court matter. So front of the court, what is the status of this matter?
Court was abated September 16th of 2020 due to the plaintiff's incarceration. On January 10th of this year, friend of the court was informed that the plaintiff was released on January 8th. The friend of the court initiated a support review. However, the plaintiff failed to submit any documentation indicating his current income. We're seeking the court's direction on how to proceed regarding a support recommendation.
All right, thank you. And I do want to indicate for the record that I previously represented Ms. Lick in a matter. There's no mandatory disqualification because it was outside of the time frame. I don't feel like it would impair my ability to be fair in this matter, but I just wanted to disclose it on the record in case Mr. Barber wanted to file any sort of motions for disqualification, but that representation is outside of the 2 years that requires a mandatory disqualification. And then also that her husband had reached me at one point regarding this matter, and I indicated to him that I could not be counsel of this matter because obviously I would be acting as the referee. So, Mr. Barber?
Yes, sir.
What are you doing at this time for employment?
I'm currently working for Do All Construction and my brother and roofing, and I'm doing side jobs. And am currently enrolled into CDL trucking school.
Okay. And how much are you making in the jobs that you're doing?
I've just started recently, and
What kind of wage are you getting paid?
well, I just made I'm making about $20 an hour. And
Okay. All right. Anything else you want to say about your income or employment?
What's that, sir?
Anything else you want to say about your ability to earn money and what you're doing as far as income and employment?
I'm trying to make money. I'm just getting myself established again, and I'm also in CDL trucking school in Cadillac at Pinnacle Trucking, and I'm trying to get through my CDL course. That way I can have my CDL license. And I'm doing this work right now to help get me through trucking school and reestablish myself.
Okay. So in front of the court, I think $20 an hour would be an appropriate figure.
Okay.
Then we have show cause matter. So Mr. Barber, you have filed some pairing time violations. Is that correct?
Correct.
All right. What are you alleging you're missing as far as parenting time?
I'm missing all of my parenting time from January 8th forward till present. I've been trying to work it out with them, and everything has left me with a dead end. And I've requested medical records from my son. I've requested multiple record cards for school. I don't even know what my son's grade average is in school or anything like that there, because I'm not given the information out to me. I've missed telephone contact where it's been disregarded. I've made multiple trips to Gaylord where they said I could pick him up at a specific time, and then they wind up driving away with my son while I'm in there at the place and in their presence after I identified myself clearly of the vehicle I'm in and where I was at. And that's on video record also.
All right, thank you, sir. Ms. Lick, what would you like to say regarding the parenting time issue?
Judge?
Oh, you got an attorney? Okay.
Yes.
All right.
Yes,
Counsel,
I'm Mike Mataloni. I represent Ms. Lick.
all right.
And
So as to those parenting time violations.
yes, I'm aware of the parenting time violations. I was actually waiting to today's hearing to put this stuff on the record and see what the court was inclined to do. But I'm sure this court's aware that the father of the young man in question just was released from prison. He was convicted of manslaughter, and the young man hasn't seen him in 5 years. He's scared to death of going to his house by himself. He is afraid of the father. He has written a couple of letters, which I have, that I would share with the court. We also have, I think, most of the video taken by my clients. They do bring the child, they do try to accommodate, but the child just simply won't go. He's afraid. He doesn't want to go to his father's house. And I've suggested that they suggest to the father that they agree on a counselor, and the young man and the father go to counseling together and let the counselor work with them so that they can try to figure out what can be done to make this young man feel safer. He's afraid, and I know the father probably doesn't want to hear this, probably doesn't care, but at the end of the day, you know, he was gone for 5 years. And my experience of 23 years, I've never seen a friend of the court take a young person and simply put them with someone who has been missing for 5 years. We know where he was, but he wasn't with the child. So the child doesn't really know his father after 5 years. And then he's told why he wasn't around for 5 years. And of course, he's afraid. Of course, the father's upset, and I understand that. I'm a father myself, but you know, you got to work through these things, and that's what I'm asking the friend of the court to do, to order that they go to, that the young man, David, and his father, they go to counseling together, and the counselor can work with them. And I would say that the counselor could indicate when he feels the young man is ready to take on one-on-one with his father as far as visitation goes. In the meantime, like I said, the young man's afraid, and the friend of the court's supposed to be about the best interest of the minor child. The parents have both been trying. The father, I think, tries to work with him, but then as soon as the son doesn't want to go, he just gets angry. Sometimes he manifests it, sometimes he doesn't, but you know, it doesn't help when he does that. And I don't understand what's the reluctance to simply go to counseling with his son, to have the counselor, the son, and the father all work it out together. My client, Miss Lick, doesn't even want to be involved in that. She wants to follow the friend of the court, but she also understands that the father's been missing for 5 years out of the child's life, and they're just throwing him back into his life under the circumstances that we have here. It's not good for the child, not at all. And the child wants to speak to the court. He does not, you know, want me to speak for him. He wants to speak to the court directly and tell them how he feels. And I think that he would tell his father how he feels and work with his father if his father was more amenable to it. And I know he doesn't like it.
All right, do you intend to file any motions to change the current custody order or not?
Well, I do, but as I said, I was waiting for today to see if the court was inclined to step in first, because like I said, the father was gone for 5 years. I've never gone to a friend of the court hearing where someone's been missing that long, where the friend of the court is saying, oh yeah, just send the child to the father's house. You know, they try to work through it. So I am filing a motion. Now that I hear that that's what you want, but I was hoping.
I think a motion's necessary. There's a current order in place. No one's asked to change that order. And I'm not going to change it on my own initiative. I think we need to have a motion to change it, and then that would be appropriate then to have an evidentiary hearing on that motion, as well as do a preference interview with the child. So my thought is that I set this matter for an evidentiary hearing to address the show cause. And then hopefully there'll be a motion that's filed so that we can dive deeper into the matter.
I'll file it this week, Judge.
Okay.
Friday, my day that I can do it.
So for our evidentiary hearing dates that are available, our next block of time would be June 11th at 1 p.m. Do you know if you're available at that time, Mr. Mataloni?
I'm actually in a trial in Sault Ste. Marie on that day.
How about June 16th?
Yeah, I'm available all day.
So we'll set this matter for an evidentiary hearing. Would you rather 9 a.m. or 1 p.m.?
9 a.m. is fine for me. I don't know what the consensus is, but
Mr. Barber, do you have any issue with June 16th at 9 a.m.?
On what matter was that? June 16th?
On the show causes for the violation, as well as then it sounds like there's going to be a motion filed to make changes to the existing order.
Currently, no, I don't think I have any problems with date.
All right, so we'll set it for Monday. Set it for Monday, June 16th at 9 a.m. Given the child's age, there would be a preference interview. I would ask that he's available at 8:45 to do that preference interview prior to starting the hearing.
what that means for you, Mrs. Lick, is that you need to bring the child to the court at 8:30. So you're there early. Just let me finish telling Mrs. Lick. Mrs. Lick, you need to bring the child to the court at 8:30 and be ready for the child to be interviewed by the judge.
Okay.
All right. Sorry about that.
Additionally, the parties need to, if you're going to have any witnesses or exhibits outside of the parties, you need to file a witness and exhibit list at least 14 days prior and exchange that with the parties. You don't need to file the exhibits with the court, just the list of the witness and exhibits. That is an in-person hearing on that date. Additionally, so Mr. Barber, you heard Mr. Mataloni indicate that, they are willing to get some counseling together and participate in that. Is that something you're interested in before we get to June?
I have been interested in counseling, and I've reached out to a counselor. Unfortunately, Miss Lick, Scarlett, has not reached out to me at any time for counseling. I have text messages that state that I reached out for counseling, and she said that she has a counselor for little Dave and has yet to give me any kind of counseling information. Everything is really kind of cold fish, so to speak. They have failed to allow any kind of communication with me while I was incarcerated for 5 years. I'm asked multiple times to get a hold of little Dave.
My question to the counseling, and if you were willing to do so, Mr. Mataloni, he's indicating he's willing to try some counseling. So I would encourage that maybe everybody try and get some of that going before we come to court in June. It certainly seems like that would be an appropriate step to take to see where things are at.
I agree, Judge. I think that's a good idea. And I would ask the court, does the court have someone that it normally uses that would be, neutral, I guess? The father selected someone. David's already in counseling. I just want to make it fair that we go to a counselor that's neutral. So if you have a suggestion, because I'm not from that county, so I wouldn't know who to go to.
I don't have a counselor to recommend, but I do indicate that it should be someone different than as you indicated, that his primary counselor. It should be an individual who doesn't have that prior history with him for this purpose.
I'll have the mother start looking and encourage her to exchange those names back and forth with the father, and encourage them to drive the young man to the counseling sessions, accompany him side till he's in the doctor's office, and wait outside so we know that the young man's going to be there. I don't want it to turn into a situation where the young man says, I'm not going to counseling either. I think that the parents should accompany him, but not into the session itself, but just to make sure that the child gets there to the session.
All right. Thank you for that. So we will adjourn this matter then until.
No, excuse me, sir.
At 9 a.m. Yes, Mr. Barber.
Excuse me, sir. Quite frankly, as far as what the attorney is saying, he mentioned his name as being David Lick. So this attorney absolutely has no idea of what's going on in this matter. As far as the inherent rights of the child, the minor child of the parties have an inherent right to the affection and love of both parents.
All right, Mr. Barber, I did mute you because we're going off track a little bit. You can unmute yourself now, but I needed to make sure you could hear me first before you continue to go on. So you can unmute yourself. Let me know if you have any questions regarding what our next steps are, but we're not in a position today to litigate and go back and forth with those kind of issues. So the attorney's indicated that he is encouraging his client to participate in some counseling. So hopefully the parties can work on that. And Mr. Barber, you would have the right also to reach out to Mr. Mataloni as counsel for Ms. Lick to help facilitate that also if you're having difficulties with her. All right, any other questions, Mr. Mataloni, or issues you think we need to address?
Just an issue that I think needs to be addressed, and that is that the current order that is in place does allow Mr. Lick, or sorry, the child's father, to go to the school, obtain information, go to known doctors. I'm going to have my client provide him with the names of the doctors, etc. But this is not something that the mother is required to give to him. This is something that he is required to go get in on his own. There is nothing precluding him from getting information from the school, from doctors, from anyone else. So the fact that he doesn't have the child's grades and all of that is, to me, lack of initiative. I will make sure that my client makes all that stuff available to him. And the phone calls have been taking place. I even have video recordings of some of the phone calls. It's just a situation, just for the court's knowledge, that the young man just doesn't seem to want to be involved. And I don't know how, as a father myself, I don't know how you make them. I mean, you can yell at them, take things away from them, but, physically, as you well know, people have gotten in a lot of trouble thinking it's okay to pick up their kid and throw him in a car and tell him he has to go, or threaten them, or grab them, or assault them and tell them they need to listen. That usually ends up with someone being arrested for domestic violence and the police becoming involved. And we will play the tape recordings for the court so you know that they have been trying. But I'd like to give the defendant, or the plaintiff, I believe he's the defendant, my cell phone number so he can reach me if he needs to. It's 517. If he wants to call and inquire about counseling and all of that. I would just ask that he waits until Friday, because I'm going to be talking to my clients about getting all that stuff arranged and trying to work with him to get this done so we can have, maybe a couple of months of counseling before the next court date. That would be nice.
That would be nice. All right. Thank you for doing that. That does conclude this matter. We'll see you all back here on June 16th.
Thank you.
We have the parties on that matter present.
Yes.
Next call, the matter of Angel Hodge.
Good morning, Your Honor. Attorney Ino Bryant appearing on behalf of plaintiff Angel Hodge, now known as Angel Casper.
Okay, thank you. All right, I do see Ms. Hodge present. I do not see Mr. Sala present. This matter was set for a show cause at 9:15. Given this is his pairing time complaint, as indicated on the notice, if the complaining party fails to appear, the matter may be dismissed. So given the failure to appear today, I will dismiss the show cause.
Thank you, Your Honor.
Thank you.
Thank you. 36 DM. We have the parties on that matter present.
Yes, sir.
Mr. Gilner is present,
Yes, sir.
and Ms. Arms is present. And Mr. Gilner, this is your objection to a child support recommendation, is that correct?
Yes, sir.
All right, let's go through your objection, sir.
So I have a statement, but I was kind of curious because we have court coming up here in a couple weeks, and we're really not going to know. I mean, we're basically going to go through another recommendation when that happens. I was wondering if we wanted to do this now or during that hearing, that 3-hour evidentiary hearing.
Let's see how far we can get here and how complicated the issue is, and then we'll decide if we need to set it on that date or if we can resolve it today.
Okay. So I'm formally objecting to child support recommendation issued by friend of the court and request hearing. Number one, unjustified increase despite acknowledgement of parole obligations. I initially objected to the recommendation due to my parole-related financial obligations, which were recognized. However, instead of reducing my support, the court increased it by adding other expenses. Two, additional medical expenses wrongfully included. The recommendation.
Mr. Gilmer, hold on. I want to go through them piece by piece. It doesn't help if we talk about 10 different
Sure.
things then. So your first objection is you're saying unjustified expenses were added?
Yeah, so I had original recommendation, and then we came to court, and then I told them about the parole, and we had another recommendation done, but instead of the child support going down, it increased.
Well, what are you saying are the unjustified expenses that were added?
So that was number two. So the medical expenses that I guess Catherine included somehow. My daughter's actually covered under my Medicaid plan. It's actually I've dealt with this with Shasta in front of the court. They sent that thing out, and then I got them the evidence, and then they sent it back to my company, and they stopped taking it out because she's covered under my medical plan.
All right, so you're saying you provide health insurance?
Yeah, I have Medicaid, so she's covered under my Medicaid.
All right, Ms. Arms, what kind of health insurance, if any, do you have for the child?
Your Honor, I have medical insurance through the marketplace. For my daughter, I pay almost $300 a month because I have her full time.
Okay. So, sure, sir, if she has coverage through mom's employer or through her mother, do you think she needs additional coverage?
I mean, if she did, I have it available through my work. If I just have to have the court open up that window for me to be able to get it, which would actually be better coverage, I think, probably for. I don't know what her mother's got for her, but I mean, if that was the situation, I mean, I could do that.
Well, so you're not paying anything right now for health insurance for her?
Well, I have the Medicaid because I'm still on parole, so I have the Medicaid, and that covers all my kids.
You are not paying any money, correct?
No, not for medical. No, I don't have any medical through my work right now.
Okay. All right, so I mean, the child support manual goes through the whole steps of who should provide coverage when it's available. Typically, if somebody has private insurance over public insurance, the private insurance is what would control. But what I can see already is this matter's not going to be a short matter to address. We do have the evidentiary hearing coming up, which is set for 3 hours. I can't imagine we would need a full 3 hours to address custody and parenting time for a child that would turn 18 a month after that. So I am going to adjourn the support objections to that April 14th date. You have any questions regarding that, Mr. Gilmer?
No, sir.
All right, any questions, Ms. Arms?
No, sir.
All right, thank you both for appearing. We'll address these issues then in addition to the motion on April 14th at 1 o'clock. And Ms. Arms, you're aware still that there is a preference interview with the child before that hearing?
Yes, Your Honor, can I just ask one question?
Sure.
This has been going on so long. Why in the world put my daughter through this when she turns 18 in May? Why not, Mr. Gilner, just leave it alone? I don't even care about the child support. I've been supporting her whole entire life. Like, this is just putting her through nonsense.
Well, I mean, I'm in a position where if a party is seeking a motion, I have to address it. I can't ignore any requests when the child is under 18. So
Okay.
we're scheduled for that hearing. If something changes, then it would change. But if not, I will see everybody here on April 14th.
Thank you.
Thank you both for appearing. I'll see you then. All right, and Mr. War, this is your motion, or you filed parenting time violations, is that correct?
Correct.
All right, and what is going on with your parenting time?
She is just refusing to let me have parenting time. I have showed up to the state police post as instructed in our parenting time motion or our parenting agreement. She's just flat out refusing.
So it looks like your parenting time was to resume on October 11th. Have you had any parenting time since that time?
No, sir.
Okay. Ms. Peel, what would you like to say regarding this matter?
She has been seeing a counselor for almost a year now, and the counselor recommends no visitation because of her PTSD. Cannot testify today due to her contract that does not allow her to do so.
Okay. And did you file any motions to stop parenting time?
No, I did not, Your Honor. I did not know I had to do that.
Well, you were here in court back in September, correct? And we had a hearing and it was ordered that the parenting time resume, correct?
Yes, Your Honor.
And did you file an objection to that recommendation?
Yes, Your Honor.
Okay. Take a look at the objection. What happened with your objection, ma'am?
Denied.
Okay. So then you understand when it's denied, then that the order remains in place. Do you understand that?
Yes, Your Honor.
Okay. And have you complied with the custody order?
No, Your Honor.
What is your plan moving forward with the custody order?
I plan to continue objecting.
There's no objection or motion. So right now there's an order in place that says what is to happen. There's no motions out there or any requests to change that. When somebody violates an order and doesn't follow an order, the court can fine them, they can put them in jail. There's lots of different options that the court has. I don't know if one of those steps is going to be necessary in order to get you to comply. Yeah, you're admitting that you've not followed the order, correct?
No, Your Honor.
So you also understand that he's potentially entitled to make up parenting time if you don't follow an order, which could then result in a lot of additional parenting time. Are you aware of that?
Yes, Your Honor.
And you're indicating right now that you are not willing to you're not willing to follow the order, is that correct?
I just want to keep my daughter safe. And my daughter tells me that he has hurt her. It is my job to keep her safe.
I mean, we've had hearings on those issues. I think there's been involvement from different agencies. And I don't think any of that necessarily came through at those hearings or agency findings. There were a lot of allegations that went unproven when we did have a hearing back in September. Has anything changed? Has there been, so he hasn't had any contact since that time, correct?
Yes, Your Honor.
And Mr. Warr, what is your actual parenting time schedule supposed to be?
Every other weekend, holiday, and parenting time, as I believe it is the holidays, and I get 6 weeks in the summer, and flip-flop on holidays and birthdays.
Okay. All right. Anything else you wish to say, Ms. Peel?
No, Your Honor.
All right. Well, I mean, certainly based on what's been presented to the court, there was a court order put into place in October. There was a period where there was no parenting time for Mr. Warr. There was an ex parte order. There was then a hearing granted for this matter. The parties had their opportunity then to present any evidence as to what should move forward based on really the lack of what was presented from Ms. Peel, that it was ordered that the parenting time resume. It appears that has not happened now. And we're approaching 6 months of it not being followed. So given the failure to follow the order, without any new allegations of anything that happened that were presented at the last hearing, I would find that Ms. Peel is in contempt. I would order make up parenting time.
Can I make a request, Your Honor?
What is your request, sir?
My parents are coming from Oregon on May 24th through the 26th. Can I have some of that time made up during that time?
All right, I'll look at a calendar and we'll see. All right, so what I'm going to do in order to address, I mean, really, you've got about 6 months of missed weekends every other weekend. So about 12 missed weekends we're looking at. Do you work on the weekends, Mr. War, or are you available?
No, sir. I'm available on the weekends.
Okay. So in order to address the missed time, what I'm going to do is indicate that there will be 12 made up weekends. So you already have every other weekend anyways. What I'm going to indicate is beginning April 4th, Friday, April 4th. That Mr. War would have every weekend for 24 straight weekends. So that would be 12 makeup weekends plus the every other weekend that he's entitled to. So we're filling in those missed weekends. So they'll have beginning April 4th, he gets 20. Well, then we run into summer. So hold on. In summer, you get every other week. Is that correct?
I think it's 2 weeks on, 2 weeks off, 1 week, 1 week. Or, yeah.
All right. So what we're going to do instead is beginning April 4th. Mr. War is going to have every weekend throughout April and May, as well as that first weekend in every weekend throughout April and May. So that's 9 weekends. Then you'll have your summer parenting time in June, July, and August. And then in September, we have every weekend in September. Every weekend in October. And every weekend in November. And then beginning December 5th, you would go back to alternating weekends. Well, beginning in December, you go back to alternating weekends with your first December weekend being December 12th. So we will obviously provide the two of you a written version of this, but essentially it's every weekend in April and May, summer parenting time in the summer, every weekend in September, October, and November, and then in December, going back to every other weekend. Any questions, Mr. War?
No, sir.
Any questions, Ms. Peel?
No, Your Honor.
All right, so at this time, I'm not imposing any fine or any other potential sanctions, which can include jail time, but if we continue to come back on violations, then obviously the penalties have to increase. All right, thank you both for being here today. We're all set. 1 DP. We have the parties on that matter present.
I'm here, Your Honor.
All right, we have Ms. Brandow present. If council could please place their appearances on the record.
Jody Doak appearing on behalf of Anjulia Phillips Kopenke. Brandow, really, actually, at this point.
John Danielski on behalf of Mr. Bargy.
Ms. Doak, this is your objection to a child support recommendation, is that correct?
It is, Your Honor.
All right. Do you think we need a hearing on this with testimony, or do you think this is something we can resolve through some brief argument?
Well, the testimony I'm referring to in my motion happened during the trial that already occurred. So I know that the judge that heard the case already has that testimony on the record. So I don't know that we would necessarily need. Well, and then Mr. Bargy is indicating that he's intending to take the Fifth Amendment with regards to his income, I think. Maybe we should clarify with him if he's intending to do that.
So your objection to the support recommendation is related to his income calculation?
His income, there was testimony at the trial that he made $300 a day. So his income is incorrect.
Mr. Danielski, anything that you want to say regarding your client's income?
He gave his income to the front of the court, and we don't object to the income that he provided to the front of the court of $21.75 a month that they had in their calculations. The mother testified at trial that she makes $16 an hour, and the front of the court put her at $2,088. I don't even know if she ever completed the forms. When looking at the front of the court calcs, it looks like they had to pull some numbers from I can't remember the exact terminology they used, but they pulled some numbers for her. But she testified at trial that she makes $16 an hour.
All right. Well, I think we're probably in a position now where we're going to need a little more time and, a 5-minute argument. So what I'm going to do is set the matter for a evidentiary hearing. So Mr. Danielski, does your client have a payroll job, or what kind of job does he have?
He's working at a car wash.
Okay. All right. I will set the matter for an evidentiary hearing. I will allow the parties to appear by Zoom for this particular support matter. My next available time would be, I would assume an hour would be sufficient, or do you think we need more?
I think that's fine. It's up to Mr.
I think that would work.
All right. So I've got June 11th at 11 o'clock available.
Take a look here.
I'm available then.
Works for me, Your Honor.
All right, so we'll do June 11th at 11. Again, I'll let you appear by Zoom. If you've got any updated income information, pay stubs, and those things that you can provide in advance, that certainly would be helpful.
Okay.
Thank you, Your Honor.
Thank you.
Thank you. I'll see you on June 11th.
Your Honor,
Yes.
complaint from the plaintiff that still needs to be addressed. I wanted to confirm if the transportation that was stipulated to resolve that, or if that needs to move forward.
All right, counsel, any response to that?
Ms. Kopenke filed that complaint, so I'd ask her to respond to that.
I'm sorry, I didn't hear what she said.
She's asking if the complaint, if the transportation order that was entered resolves your complaint with regards to parenting time.
It should. This is the first time that I've had him since then, and the first go around with the pickup was fine. So yes.
Okay, so she's indicating on the record that she's going to withdraw her parenting time complaint then.
All right, thank you for that clarification. You're all set. We'll see you June 11th.
Thank you.
Thank you.
Thank you, Your Honor.
We have the parties on that matter present.
Here you
All
are.
right, thank you. And Ms. Plita, can you hear me okay?
Yes, can you hear me?
Yes. And ma'am, this is your motion regarding custody, is that correct?
Yes.
And what are you seeking to change?
I want full 100% custody all the way down the line.
All right, full 100% custody down the line. Does that mean you're requesting sole legal and sole physical custody?
Yes.
All right, Mr. Flynn, what is your position to that request?
I mean, I'm not really sure what kind of position I'm exactly in here, Your Honor. I am incarcerated, but I am very involved in my children's lives, so I'm not really sure that I want to just 100% just give up on having legal privileges to them as being their parent, as I see that they need both parents in their life. And so, I mean, Kayla's a great mom. She does great things for them, and without her, you know, they'd be in a lot worse position than they are right now. But that doesn't mean that I can't be a great dad, or I have not been a good dad in their life either.
All right, so it looks like the parties currently have joint legal custody. Is that correct, sir?
Yes.
And then Ms. Plita does have the sole physical custody, and you have some parenting time that is scheduled that apparently you're not in a position at this time to exercise. Is that correct?
Yes, sir.
So would you agree at this time that your parenting time, that you would not have parenting time? Do you know roughly your release date?
As of right now, I'm on track to be released in August, as my ERD, my earliest release date was May of 2026, but I was approved to go to the SAI boot camp program, so I should be released in August sometime.
Okay. So you're going to start that program in the near future?
Yes, within the next 30 days.
Okay.
They just don't give you an exact day that you go, but I was approved to go. I did fill out the paperwork and send it to be signed, and I started the whole process with that a month ago.
All right. So since there's no agreement, the court's kind of in a position to set the matter for a hearing.
Can I make a statement real quick about that?
Certainly.
Okay, so I have no intention of like keeping Jacob and Riley from Anthony, like at all. I have no intentions of him not being a father to them. I just think for right now, until he is able to come out, I mean, he says that he should be released in August, but that's if he gets into boot camp and if he completes it. And then if not, we're looking at May of 2026 before he's released. And I think once he does get released, then in a couple months afterwards, we can come back, he can file, and we can come back for more parenting time. But I feel like right now it'd be the best bet for the children for me to have them 100% and then have him be able to get out of prison, find a stable home, a job, a car, all these things, so he can adequately do his parenting time. And we have no concern, like no complaints, no concerns. I just basically want it to where I can get full custody so I can do all medical, school stuff, everything without having to talk to him first and wait to speak to him about medical decisions, just everything. And I want, when he does get out, we need to be able to like prove that he is going to be sober and stay sober. 'Cause look what happened, and here we are. I just don't want my kids to go through that again.
Well, you could have temporary sole legal with the agreement that upon his release, he goes back to joint legal. Are you comfortable with that, ma'am?
I guess for now, I don't want him to get out and then a month later, 2 months later, he still doesn't have a stable home, doesn't have a car, doesn't have a, a stable job. And, my kids are now sitting in a hotel room, or he can't even do his parenting time because he can't come pick them up. And then I could possibly get in trouble because he can't do his parenting time. It's a lot.
At first, I was talking about legal custody because, you indicated your concerns about legal custody right now, as far as if something happens to the kids, having to reach out to him to get the joint decision-making might be difficult. So for the joint legal decision-making custody, you could come to an agreement that says temporarily you have the sole legal custody, but upon his release, you go back to joint legal. So again, that's just discussing. So that's separate from parenting time. Then we can discuss how we would handle parenting time. And see if you can reach an agreement. And if you can't, then we would just set the matter for a hearing. You could agree that upon his release, parenting time would be as the parties agree. And then if you can't agree, then either party has the right to file a motion for specific parenting time.
Okay.
Are you okay with some language like that?
Yeah, we can. Yeah, for now we'll do all that, and then once he gets released, I guess he can file or refile. We'll come back and revisit everything, the parenting time.
Mr. Flynn, what do you think about that type of language?
I would be okay with that. Upon my release, have some kind of court structured plan, a reunification plan to be able to be to the best benefit of the children. And I would definitely be okay with the temporary custody, as I'm in no position to make those decisions right now. So I'm definitely more than forthwilling with that.
All right, thank you, sir. I certainly appreciate that reasonableness. So, Ms. Bleed, I'm going to start with you. Would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, Ms. Bleed, are you asking this court, and are you in agreement with a temporary order that would grant you the sole legal and physical custody? And then upon Mr. Flynn's release from incarceration, you would go back to joint legal custody, and that parenting time would be as the parties agree. And then obviously, if the parties can't reach an agreement, then either party can file a motion to establish a specific parenting time agreement.
Yes.
And do you feel that agreement is in the best interest of the children at this time?
Yes.
All right, thank you. Mr. Flynn, would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Mr. Flynn, are you also asking the court to enter a temporary order that would grant Ms. Lita the sole legal and sole physical custody of the children and then once you are no longer incarcerated, it would go back to joint legal custody. Parenting time would be as the parties agree. And if the parties cannot reach an agreement, either one of you would have the right to file a motion for specific parenting time.
Yes, Your Honor.
And you believe that's in the best interest of the children at this time?
I do, Your Honor.
All right. All right. Well, thank you both for appearing. We will draft that order. And then, like I said, once you're released, if the two of you can't reach an agreement on parenting time, then you're free to file a motion. Okay.
Thank you.
All right. Thank you.
Thank you.
I'm here, Your Honor.
All right. Thank you. And you see that we have Ms. Tabaka. Ms. Tabaka, if you could please unmute. Let me know if you can hear me okay.
I can hear you. Are you able to hear me?
Yes, thank you. And Mr. Tabaka, this is your objection to a child support recommendation. Is that correct?
Correct.
And what is the basis of your objection?
Two things. The days that they have for me on the number of overnights is wrong. I actually have them for 17 more days than what the paperwork says. And then also my income or my child support tripled since I got a new job. However, my income did not. I'm looking at basically bringing home about 800 a week to 12. Now I'm bringing home 1,200 a week. It's roughly, and And so that's 1,800 a month. That is my difference. And she's with this new review, she's getting 1,300 a month of it. And to me, that just seems extreme.
All right, so is your income correct in the calculation?
Yes.
Okay. Ms. Tabaka, as to the number of overnights, what do you think is the correct overnights?
I don't have that paperwork in front of me, but I think friend of the court did have it correct. When I filled out the paperwork, I also factored in the week on, week off during the summers.
All right, friend of the court, any help with the overnights in this matter?
I had gone off of what the order had said and tried to factor it in as fairly as I could. There was a little bit of a discrepancy between the two parties, so ultimately I fell back on the order.
Is that where you got the 105 from, was following the order?
Mm-hmm.
Just so I can find them in the order.
And then
So what is the parenting time order, Mr. Tabak?
It is every other weekend, and they are 3-day weekends. So it's Thursday night through Sunday evening. So Friday, Saturday, Sunday, every other weekend. And then on the off weeks, it is a Thursday overnight. And then that is during the school year. And then during the summer, it goes to, I get 7 weeks. And we typically do a week on, week off during the summer. And I also get them on Tuesday nights for dinner, every other Tuesday night for dinner for 2 hours. And that puts me at 122 days. And the paperwork I got from friends of the court says I have them 105.
Okay. Is Tabaka any issue with the 122, or do you think it's the 105?
I think it's the 105 from what the friend of the court said. I'm just following the custody order.
All right, well, I will later today on a break do the math, and we'll do a written opinion on the number of overnights. And then, sir, did you have an issue with the income of Miss Tabaka?
So, yes. So basically the problem I have is that, she is capable of obtaining a higher income because she's an RN, and I don't know why she gets away. So I know that, it's all factored in on her income and my income. And basically what it boils down to is she gets to work not even 40 hours a week and gets to have a smaller income. And because of that, because I have a larger income, have to pay more. And to me, in terms of us both taking care of our kids, I don't know why I'm on the hook for so much more when I shouldn't be the only one that has to do that.
Ms. Tabaka, anything that you'd like to say regarding the income?
Yes. So Mr. Tabaka is incorrect. I have a nursing degree, but I do not have a license. I let that lapse in 2015 when we were still married, and I was having a high-risk pregnancy, and it was at the best interest for my health and Lucas's health not to go back into healthcare because both kids have appointments with COP for therapies, and I was the primary parent doing those appointments. So I obtained a job at NEMSCA Head Start in 2016 as a bus aide and worked my way up and was able to get my CDL. And now I currently work at Gaylord Schools. I'm a bus driver in the morning and afternoon and a float and structural assistant in between the bus routes. So I average 8 hours a day or 36 to 40 hours a week. And then during the summer, I work with the maintenance department at the school and I help paint classrooms or move classrooms or whatever the need is. And that position is also 40 hours a week during the summer.
All right, is the hourly rate the same for all those jobs?
No, the bus driving position is $24.84 and the maintenance position and the instructional assistant is $16.
Front of the court, did you have all that information when calculating her income?
I don't know. I would have to look at my notes to see.
All right. I think what we'll do is review it and make sure we calculated all that in. So, ma'am, you work during the school year. The bus driving is about how many hours?
The bus driving is 20 hours a week at $24.84. And then the instructional assistant is 20 hours at $16 an hour.
Okay. And then in the summer, it's 40 hours at the 6.
Yes.
Okay. All right. So we'll make sure we have it calculated at that. If it was at a different number, we'll change the calculation to that calculation. I don't find that she's underemployed with the nursing issue, given the history of the work and when that was last, her profession. But we will make sure that her income reflects those hours that she was just given. I don't know if the caseworker had all that information at the time when calculating the income. So if the income changes, we'll change the income, as well as then I'm going to take a look at the number of overnights. And if there is a change in that number, we will issue a new recommendation. Any questions, Mr. Tabaka?
I guess the only thing I would like to add is when we were going through our alimony, part of that was on an oral contract that she would obtain her nursing license with the money that I was paying her. And if she hasn't done that, I feel I'm vested with that. So I would need some sort of recompensation back to me if she has not done that.
All right, well, that's certainly a separate matter than what the court has on the docket for today. So if that does give rise to some type of motion, you are certainly free to file that. All right, we will send out a written recommendation then based on that information once we review the income for Ms. Tabaka as well as the overnights. All right, thank you both for appearing. You are all set.
Thank you.
Thank you.
Do we have Amber Wilson present? Not good. Ms. Wilson is present. And Mr. Gildner, this is your objection to a child support recommendation. Is that correct?
Yes, sir. We just had that hearing, so it's going to have to get readjusted. I'm okay with whatever it gets probably readjusted to, but since you gave me parenting time back, it's going to change anyway. I just haven't gotten that recommendation yet.
All right, so your objection is based on, in this case, is based on what?
Well, basically, I mean, my original objection is not really valid anymore. It's more of, it's going to have to be readjusted based on your ruling the other day. So, and you had made a comment that it would have to be readjusted. So I'm just waiting on that readjustment. So I don't even know if the hearing today is, I mean, really going to go anywhere because we have to readjust it anyway.
Well, once there's overnights, then those overnights will be factored in.
Yep.
But until there's overnights, then it would remain at 0 overnights.
Yeah, I start overnights. I think it's June. I think it was. And then it goes to overnights all the way through the summer, and then it goes to regular parenting time, I think in September. Since September 12th, I think it was. Based on the period of 0 overnights where we're at currently, do you have any objections to address on the recommendation? Not really. The problem I have is, like, right now I'm taking care of my mom and dad. They both have cancer. Neither one of them are working. So I'm kind of taking care of all that. Plus, going to be paying the child support, plus driving from Grayling to Vanderbilt every day, which costs me about $400 a month in gas. If the recommendation goes forward with the other child support for the other case, It takes 50% of my income. I wouldn't be able to afford gas to get back and forth to work. So that would change my situation in the short term or even in the long term.
Well, do you feel your income was inaccurately calculated in the current recommendation?
No, I think that was right, Your Honor.
Okay. All right. Anything else you wish to say, sir?
No, sir.
All right. Well, based on what was presented on this matter, I would deny the recommendation, or the objection on this matter. I mean, certainly once the overnights have changed, front of the court knows that they will prepare a new recommendation once the overnights begin. Correct, front of the court?
Yes, we could do it as a tier after the June 21st when the overnights start.
Okay. And I think that at some point the overnights might change a little bit. There might be shorter time and then longer time, but certainly front of the court will be on top of that. And sir, if you notice that those changes aren't made, then you certainly are free to contact front of the court and make sure that there is a new support recommendation done as your overnights begin. Okay.
Okay.
All right. Thank you for being here. You're all set.
I am here.
Yes, I'm here.
All right. We do have the parties present. This is a status hearing on a referral from a denied on an ex parte order regarding custody. All right. Who filed the ex parte?
I did. Saria Burns.
All right, thank you, ma'am. And are you still seeking at this time to change custody?
Yes, I am.
All right. What change are you seeking to make?
I'm seeking to make a 50-50 change to custody over our son, Aaron, to hopefully alleviate some of the overwhelm and stress that Kyle Vordermark is having in managing our child. I feel this is appropriate because in our past relationship, I've watched the honeymoon phase where it's slowly escalating.
Hold on. I don't need to get into all the reasons why. I just want to know what you're seeking to change. Today's not the actual full hearing. So,
okay.
Right now you have standard parenting time?
Yes, I have him every other weekend. I have him 50-50 during summer, and then I have him according to parenting time on breaks and stuff, holidays.
Yes. So right now you got standard parenting time and you are asking to have week on, week off parenting time?
Yes, sir.
All right. Mr. Votermark, are you in agreement or disagreement?
Disagreement, Your Honor.
All right. Then what we would do is set the matter for a evidentiary hearing. Ms. Burns, at a hearing, do you intend to call witnesses or just provide your own testimony?
I intend to call witnesses.
Do you know about how many witnesses you might call?
Just one.
All right. Mr. Votermark, how about you? Do you intend to call witnesses or your own testimony?
I will call witnesses as well. And I will have no more than 2.
All right. I just asked because we either set hearings for 1 hour or up to 3 hours with the party's testimony and multiple witnesses. I think the 1 hour might be pushing it. So we would set it for a 3-hour hearing. Are the parties available on June 11th at 1 o'clock?
Yes.
Yes.
Okay. And how many minor children are involved?
1, Your Honor.
Yes.
1, okay. It looks like that child is 11 years old or so?
Yes, sir.
Correct.
Okay, so there would also be a child preference interview. So whoever has the child that day should have the child here at 12:45 for the preference interview, which is a meeting with me. That's a confidential meeting. We then begin the hearing at 1. That is a in-person hearing. The parties need to file, if you intend to call any witnesses or provide any exhibits, you need to file a witness and exhibit list with the court as well as the other party at least 14 days prior to the hearing date. Any questions, Ms. Burns?
No, sir.
Any questions, Mr. Vordermark?
No, sir.
All right, thank you. You both are all set. We'll see you here on June 11th.
Thank you.
Parties on that matter present.
Yes.
All right, let's we have both parties present. This is a motion regarding support. Ms. Martin, this is your, well, it looks like you've signed the motion, but you both are requesting the same thing. Is that correct, ma'am?
Yes.
So what are you requesting, ma'am?
We missed the deadline to object to the new support order due to illness in the house, and this is just trying to go back to the original support obligation.
Okay. And you are the receiver of support, is that correct?
Correct.
Okay, would you please raise your right hand? You solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth.
Yes.
So, Ms. Martin, you're asking that the support be changed and that the prior amount that was in effect before remain the current support amount?
Correct. It was about 250, I believe. Yeah.
All right, I think I see 257.
Yeah.
But you understand that the new calculation set it at 484?
Correct.
And are you making this decision freely and voluntarily?
Yes, sir.
Are you able to adequately meet the needs of the child without any additional support?
Correct.
And do you believe this is in the best decision for the minor child?
Absolutely.
Thank you. Mr. Rauch, would you please raise your right hand? And do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
And sir, you're also asking that support be calculated at the prior amount, not the new amount that was done?
Yes.
And do you believe that the child will be adequately cared for in both homes with that support amount?
Yes.
And you believe it's in the best interest of the child?
Yes, I do.
All right, well, given the testimony of the parties then, I will grant the motion to have the support remain at the amount before that new calculation.
Thank you.
Thank you.
Morning, Your Honor. Elliot Blumberg on behalf of Mr. Ferris, who's appearing via Zoom from my office.
Thank you. And Ms. Ferris, can you hear me okay?
Yes, I can.
Thank you. Mr. Blumberg, as plaintiff's counsel, what is the status of this matter?
I've been informed that the parties have come to an agreement on all of the issues relating to custody parenting time. And I think if my understanding is correct, we can place that on the record today.
Okay.
My understanding is that the parties will share joint physical custody of the 3 minor children. And it may sound a bit unusual, but I've been informed that Mr. Ferris will have sole legal custody of those 3 children. The parties have agreed to a parenting time schedule of equal parenting time. And again, the actual computation of the days are equal, but it's not clear to me totally what the schedule is. And perhaps they can indicate more clearly than I could. But that's my understanding.
So Ms. Ferris, as to the actual schedule of parenting time, do you guys have a set schedule or is it going to be as you agree?
Nope. So we know it's unusual. But it just works better for our children. So I will go 5 days and then he'll go 2 days and then I'll go 2 days and then he'll go 5 days. Our children weren't doing too well with 7 days straight away from both of us. So we kind of just broke it up like that. And it's been working for us that way. So
5 days with you, then 2 days with dad.
yep. And then 2 days with me again.
5 days with dad.
Yeah. Yep.
All right. So in a 2-week period, you both have 7 days, correct?
Correct. Yeah. It's basically week on, week off. We just kind of split it up so the kids weren't away from neither one of us for 7 days straight.
And as to holiday pairing time, do you have any agreement on that, ma'am?
I have been just working that out amongst ourselves. We've done pretty well sharing that.
And so holidays as the parties agree?
Yeah, yep.
Okay. And then Mr. Blumberg, I don't think there's been a support recommendation done. Anything that you want to say regarding support?
Well, my understanding is that currently there is some state assistance involved. There's going to, at least initially, be a need for support. But ultimately, my understanding is that that may not be the case.
All right. So we'll do a support recommendation then based on equal, and then if there's any changes, because I do know that I didn't have a note that there was that assistance. All right, Ms. Ferris, would you please raise your right hand?
Yep.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Yeah, Ms. Ferris frozen up. Can you hear me okay, Ms. Ferris?
Oh, can you hear me now?
I can now, yes.
Is it working now? Okay, yes, I do. I'm sorry.
All right. So, ma'am, are you asking the court to enter an order that grants the parties joint physical custody of the minor children, with Mr. Ferris having the sole legal custody of the minor children?
Yes.
And additionally, the pairing time would be a rotating schedule over the course of 2 weeks, where 5 days in a row with you, then 2 days with dad, then back to 2 days with you, and then 5 days with dad. Is that correct?
Yes.
And you will do holiday parenting time as the parties agree?
Mm-hmm.
And do you feel this agreement is in the best interest of the children?
I do.
Thank you. Mr. Ferris, would you please raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Sir.
And sir, are you also asking the court to enter an order that would grant the two of you joint physical custody, and you would have the sole legal custody of the children?
Yes, sir.
And parenting time would be 5 days with mom, then 2 days with you, then 2 days with mom, and 5 days with you, and that cycle would repeat.
Yes, sir.
And you would do holidays as the two of you agree, is that correct?
Sure.
And do you feel this agreement is in the best interest of the children?
I do.
All right, thank you, sir. Mr. Blumberg, do you think there's anything else we need to cover?
No, I don't think so, Judge. Thank you.
All right, we will prepare that order as well as a child support recommendation, but let me see if front of the court needs any information from the parties.
I would need both parties' information, the questionnaire, and it appears that neither one has completed the SMILE program.
Okay, so we do need the questionnaires, the financial questionnaires done. Mr. Ferris, do you still have that paperwork, or do you need a new copy of that?
I believe I still have it. Yes.
Okay, and Ms. Ferris, do you have that paperwork, or do you need a new copy?
Nope, I still also have it.
All right, so you both should try and get that in within 14 days, okay?
Okay.
And as indicated, there is the SMILE class that you're going to need to complete also. All right,
Okay.
Thank you everyone for appearing. You are all set and can sign off.
Thank you.
Do you have the parties on that matter present?
Yes, Judge Elliot Blumberg, on behalf of Mr. Long, who's just arrived. No, he's been sitting patiently in our waiting room, so he is here.
Thank you. Do we have Ms. Brown present? Does not appear that Ms. Brown is present. Mr. Blumberg, what is the status of this matter?
Well, Judge, regrettably, we're here because we had an agreement that was placed on the record. The court directed our office to prepare the order reflecting that agreement. We prepared the order. My client signed it. Ms. Brown has not signed it. So I don't know what else we can do at this point to get this order entered.
All right, so the parties did place the agreement on the record, it looks like back in August.
Yep.
Does your client have contact with Ms. Brown or not?
Yeah. Yeah, he does.
Got the girls out Sunday afternoon like I always have.
I mean, they're following the agreement, but there's no written order That's been,
Okay. And she is not cooperating with signing it, you said?
right.
Front of the court, any information on this matter? Was there an issue with some additional language that was needed?
Right, we would need to consolidate the previous case, which was 2015 15897-DP.
Apparently, Mr. Blummer, there's some consolidation language that we need in an order.
All right, I was not involved in that case, so I'm not exactly sure what needs to be added.
Okay. It's going to be a simple line, because I think the parties had a prior case at one point. Is this a case of DP? They had a prior case involving one child. So just a simple line. Going to be consolidated, and certainly the front of the court can assist with that paperwork.
I mean, would it accomplish, I mean, is the third child not mentioned in our order? Is that the problem? Well, I guess I can look. Why am I asking you to look?
So in front of the court, you're just indicating that in the order that was submitted, that you need that language, that this case is being consolidated with the other case?
Correct.
Okay.
And do I need to reference that other case number, I'm assuming?
Yes.
And could you give that to me?
Yes, that is 15-015897 DP.
Okay. And that's all we need to do is simply add that additional paragraph?
Yes.
Okay.
So if you add that line and submit it, and it is consistent with what was previously placed on the record, then the court could proceed and sign the order.
Even without Ms. Brown's signature?
Well, I mean, preferably if you can get her signature, but if she's not going to cooperate, we do have the agreement that was placed on the record. So if it's consistent with that agreement, I think the court can proceed forward.
Okay, we will certainly.
But certainly try and secure her signature first. Yes.
I will twist her arm if I can find her. So, thank you.
Thank you. I see Mr. Rogers present, but we need you to unmute, sir.
Can you hear me?
I can, thank you.
Okay.
All right, this is a friend of the court petition. Friend of the court, what are you seeking to do?
Your Honor, support was abated back on December 13th of 2021 due to the defendant's incarceration. On October 24th, 2024, we learned that he was released and initiated a support review. We did not receive any information as far as the defendant's income, as he indicated he was not working. However, we do need to have something to proceed with the calculation.
All right, thank you. Mr. Rogers, are you currently employed?
Yes.
All right. What do you do for work, sir?
Install windows.
Okay. Are you self-employed or working for a company?
Working for a company.
Okay. How long have you been with them?
Just started.
Okay. Is that a full-time job?
Yeah.
Okay. So in front of the court, perhaps if you can speak with Mr. Rogers, get that information from him.
Absolutely.
So Mr. Rogers, are you able to provide your financial information, the income information to the friend of the court?
Yes.
All right. So I'll indicate that you are to provide your updated income information to the court so that a support recommendation can be prepared. Any questions, Mr. Rogers?
I'm sorry, what?
Any questions, sir?
No, not on this one.
All right. I know you've got a second.
Yeah,
second
I think I got
file.
another one.
I'm going to go ahead and call that. I know we're a little early, but This is related solely, I believe, to again, it's the same issue. So I will call the matter of Michelle Bosquet versus Joseph Rogers. In front of the court, is it the same situation or is it different?
Correct, it is the same.
Okay. Mr. Rogers, anything that you wish to say on this file?
I mean, the mom hasn't had the kids in the past 2 years.
Okay. Are the kids in foster care, or are they with a? Are they kids
they're staying with the mom's uncle.
Is that through a court order or just?
Yeah.
She's just had.
Yeah, it's yep.
In front of the court, are you aware of that information?
I am not.
Okay.
Yeah, I know the mom, when I was incarcerated, the mom lost rights due to, there's 56 allegations. So DHS stepped in and took them from her and placed them with the kids' uncle.
All right. I do see in the file there's a notice of a proceeding in probate court. All right. So front of the court will certainly take a look at that. But if there is any need to examine the income again, you would have to submit your income information, which could be used in any potential support recommendation here. Do you know, sir, if the genetic testing has been done at all? I know we had a prior hearing about
the DNA on the youngest one.
Yes.
I was told from the caseworker in front of the court that Michelle has to do it first before I can do it. But I don't think she's gonna go do it. I mean, I'm trying to get it done so I can prove that, that the youngest one's not mine because, I got locked up November 8th of 2020 and got released October 24th, 2024. And the baby was born November 22. So I'm definitely trying to get that DNA done so I can get that one off the caseload.
Sure. All right. Well, I'll make sure that we follow up on that and see where we're at with getting that addressed. Because I know we did issue that order back in January.
Yeah. Now, is there any way I can, do I have to wait for the mom to do the test first, or can I just, go ahead and try to get a day and do it?
Well, I think you can have a sample done. You can do it. Yeah. Just needs a count upstairs. All right. It's Angela or Kara Kent. All right. So if you can get hold of Kara Kent at the prosecutor's office.
Okay.
You can do your sample in advance. We just obviously need the child for the comparison's sake, but you can do yours and get that part taken care of.
All right.
And then we will get that financial information from you. I think if the court has to do a support order, that we not include that younger child at this time, basically a bait for the younger child, given the dates involved. It would be, I think, very difficult for you to be the father while you were in prison if you weren't having visits. So we'll do what we can there to assist you, sir. Okay.
Okay.
All right. You were all set. Thank you.
All right. Thanks.
We have the parties on that matter present.
Yes, sir.
Thank you. So this was referred to the front of the court after a denial of an ex parte motion filed by the defendant. Is that correct, Mr. Belding?
Yes, Your Honor.
All right. So are you looking then, I know your ex parte request was denied. Are you looking to make any changes at this time to the custody of parenting time?
Yes, at least for schooling, I would like her to be physically with me.
What is your current order?
Week on, week off.
Okay. Are you guys in the same area or different areas?
I have been in the same area for 7 years now. She was living in Mansalona and since has moved to Gaylord. And from what I understand from CPS is staying in a hotel.
Okay. So you're asking to serve. One second. So Mr. Belding, you're asking to have the primary custody during the school week?
Yeah, it's important that our daughter, who's already struggling in school, has a stable home structure. And right now, I don't think Caitlin can provide that. I'm not saying she's a bad mom at all, by any means. I just think with Allie being behind, the school has already reached out since this living change at mom's and Allie's having issues in school. I think it's really important that we do what is best for Allie and keep her in a safe, structured environment so she can continue her learning and get on the correct path.
All right. And Ms. Dewey, what is your position?
Your Honor, the only reason why we're at this hotel is because the house we were supposed to move into fell through, and I moved to Gaylord to relocate closer to the girls' school. And I know Mr. Belding still works, but I'm a full-time mom. Now, like, I stay home. My fiance makes enough for me to be able to stay home, for me to be with Allie all day. And like I said, we should be knowing about a house within the next week or two. And CPS is okay with us being at the hotel.
All right. So you're not in agreement with the change?
No, I think the week on, week off should still stay, because I drive her, like, I literally drive her to school every day. I have her pick her up from school every day. I even watch my niece as well, that I pick her up too. And I was just be more on his, like, and that he'd be putting more of that workload on his grandmother, who already does a lot for him. And I mean, I know she's a very good grandmother. I don't want, like, I feel like I should still have her my week.
All right. So if there is no agreement, what we'll do is set the matter for a hearing. Mr. Belding, do you intend to call witnesses or just provide your own testimony?
I have like 3 witnesses I would like to call for it. Yes.
And so your request is to change because of her housing situation?
Well, that and having CPS involved for the reasons that they are, the way that I found out from her husband's parole officer, who said he had to contact CPS due to the living conditions in that house. Then I talked to CPS, Danielle is her name, from Antrim County CPS, and she told me they're going over sober caretaking, so using drugs and alcohol with the kids and not with the kids, and safe sleep habits. And I'm just worried about the well-being of Allie when she's there.
Okay. All right. So what I would do is set the matter for a hearing. Are you available June 16th at 1 p.m.? It's a Monday.
1 second. Let me pop my calendar right here and I will tell you. You said June 16th?
Yes.
Yes, I am.
Ms. Dewey, any issue with that date?
No, Your Honor.
All right, so we'll set this matter for an evidentiary hearing on June 16th at 1 p.m. That is an in-person hearing. Additionally, if you intend to introduce any exhibits or have any witnesses, you do need to file a witness and exhibit list at least 14 days prior to the hearing date. Then you need to provide the other party a copy of the witness and exhibit list, as well as any potential exhibits. Any questions, Mr. Belding?
No, thank you, Your Honor.
And Ms. Dewey, any questions?
No, thank you.
All right, we will see you here June 16th unless the matter resolves itself. Thank you.
Thank you very much.
You have the parties on the Workman matter present. If you are present, please unmute.
Can you hear me?
I can, thank you, sir. And Ms. Workman, can you hear the board okay? All right, I'm showing that we have Rebecca Workman present. Let's Looks like her audio should be on. All right, Ms. Wortman, can you hear me okay?
Yes, now I can. Thank you.
Thank you. All right, this is an initial hearing. It's a new divorce matter. Ms. Wortman, you are the plaintiff, so I'll ask you first. Do the two of you have any agreements at this time regarding custody and parenting time?
Yes.
All right, what is that agreement?
Essentially, William will live with Scott. He kept the family home, so William will live with him. And then he's 16, almost 17, so he kind of gets to choose freely where he wants to be. So spends time as he sees fit.
All right, so you would be agreement that Mr. Wortman would have the primary physical custody and parenting time would be as the parties agree. Is that correct?
Well, I think we agreed to 50-50 custody if that's what we were gonna, if there was going to be an order for that, but 50-50 custody. But yes, he would live there primarily.
All right, I'm just trying to figure out the best way to word it because, you know, if he's living more with one parent, and that parent has the primary custody. So is he living equally with the two of you or more with one of you?
I would say he's, based on the situation, one of our other children has lived with me since I moved out. One of our other children has lived, an adult child, but she's lived with me. So William has stayed more with Scott. Yes.
Okay. And then you would agree to joint legal custody. Is that correct?
Yes.
Have the two of you had any discussions regarding child support?
We have, yes.
And what discussions have you had regarding child support?
We've agreed that neither of us was interested in asking for any child support or requesting it.
Right. Do you receive any public assistance, you or the child?
I do not know.
And Mr. Wortman, is it correct then that you guys would have joint legal custody? Do you feel that you have the primary physical custody or that it would be joint physical custody?
I agree with everything Rebecca has said. I agree that 50-50 is ideal and how I feel it's going. I know with the current situation with our other daughter, she does her best to be a part of William's life, and I feel like everything is going accordingly.
Okay. All right, so then I will start with you, ma'am. Would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
So, ma'am, is it correct then that you're asking the court to enter an order that would grant the two of you joint legal and joint physical custody with parenting time as the parties agree?
Yes.
Okay. And it's also true that you are not receiving any state or federal assistance. Is that correct?
That's correct.
Okay. And do you believe, and you're also not asking for child support in this matter, is that correct?
That's correct.
Okay. And you believe this agreement is in the best interest of the child?
I do.
Mr. Wortman, would you please raise your right hand? And do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And sir, are you also asking the court to enter an order that would grant the parties joint legal and joint physical custody?
Yes.
And parenting time would be as the parties agree?
Yes.
Are you also asking that there not be child support in this matter?
That is correct.
And do you receive any public assistance?
I do not.
All right, so based on the parties' statements, then the court will enter an order that grants the parties joint legal and joint physical custody. Parenting time would be as the parties agree. A informational recommendation does need to be prepared, though, based on equal overnights. The two of you may have to do some additional paperwork related to support, and that's certainly something you can talk to your caseworker or the friend of the court about. But we do need to at least prepare an informational child support recommendation. Friend of the court, do you have the questionnaires back from the parties?
I do not.
Okay. So both of you should have received some paperwork from the friend of the court, the financial questionnaire. Do you still have that, ma'am?
I do. I faxed mine in, but it sounds like she didn't receive it. Miss.
And sir, do you still have that paperwork?
I do.
All right.
I was assuming, Your Honor, that since Rebecca and I were both in agreement, I didn't need to fill all that out.
Nope, we still need it. We're going to prepare what's called an informational recommendation at a minimum. I'm not ordering support at this time, but we are going to prepare that informational one. It won't become an order at this time, but we still need to have that prepared.
Okay.
So just have those questionnaires in within 14 days. You know, ma'am, if you tried to fax it, you can confirm with friend of the court if they got it. But if not, you may need to either refax it or drop a copy off. Okay.
Sure, that's no problem. I'll drop one off. Thank you.
All right. Thank you both for appearing. You are all set.
Thank you.
Thank you.